This episode is for litigators, not AI enthusiasts, not early adopters. Litigators who have a matter in front of them right now and want to know exactly what Claude can do at each stage, and exactly what it can't. 5 workflows, 1 full matter. From the moment you're instructed to the day you settle. Every workflow includes the exact prompt. Copy it, adapt the specifics to your matter, and run it. That's all this is. Before we get into each workflow, here's how to use this episode. The 5 workflows follow the matter arc. Workflow 1 is matter intake. Day 1, you've just been instructed. Workflow 2 is document triage. Your client's documents have just come in. Workflow 3 is the motion stress test. Your draft is complete, you're about to file. Workflow 4 is deposition architecture. You're building your questioning strategy. Workflow 5 is the settlement read. The agreement is drafted and your client wants to sign. If you're at a specific stage right now, go straight to that workflow. If you're watching to understand the full system, watch straight through. Each workflow includes the exact prompt to use and an explanation of what Claude produces and what you do with it. No assumptions. Workflow 1, matter intake. You've just been instructed. You have the brief, the complaint, or the client's summary in front of you. Before you've read every document, you need to know what the case is actually about, the core dispute, the key parties, and where the legal risk sits. Reading it cold and trying to hold all of that in your head at once is how you miss things on the first pass. Here's the prompt. You are assisting a commercial litigator acting for the defendant in a U.S. federal court matter. Read this document and give me 1. The core dispute in 2 sentences. 2. The parties and their roles. 3. The key legal issues as you identify them. 4. The 3 facts that seem most significant. And 5. Anything that strikes you as unusual or that I should flag to the client immediately. Do not add legal citations. Flag any assumptions. Paste your brief or complaint into Claude after that prompt and run it. What you get back is a structured orientation note. Core dispute, parties, legal issues, key facts, and flags in under 60 seconds. This is not a substitute for reading the file. It's a foundation. That means your first read is an informed one, not a cold start. You'll spot things Claude missed. You'll also find Claude spotted things you would have got to on page 4. That's the workflow. 20 minutes of orientation, not 2 hours. Workflow 2, document triage. Your client has handed over a folder of documents before formal discovery begins. You need to understand what's in there, what helps your case, what hurts it, what's missing, and what you need to go back to the client to get. Reading it cold takes hours, and when you're reading cold, you're focused on what's in front of you, not what should be there and isn't. Here's the prompt. You are assisting a litigator acting for the plaintiff in a breach of contract matter under Delaware law. Read these documents and tell me. 1. Which documents support our position and why? 2. Which documents could be used against us by opposing counsel and how? 3. What the documents suggest is missing, what should exist but doesn't. And 4. What I need to go back to the client to clarify or obtain. Structure your response by document, then by issue. The output is a document-by-document assessment organized by issue. What helps, what hurts, what's absent, and what questions to put to the client. The most valuable part of this output is number 3, what's missing. Claude reads for gaps in a way that's easy to miss on a first manual read when you're focused on what's in front of you. The missing email chain. The contract schedule that should exist but wasn't provided. The board minute that should record the decision. That's where this workflow consistently produces something worth acting on before discovery formally opens. Workflow 3. The motion stress test. Your draft motion is complete. You believe in the argument. Now you need to read it as opposing counsel will, looking for the weakest proposition, the authority that doesn't quite hold, the factual assertion that invites challenge. Claude takes the adversarial position, so you can strengthen before you file. Here's the prompt. You are acting as senior opposing counsel, reviewing this motion to dismiss. Your job is to find every weakness, arguments that overreach, authorities that don't support the propositions cited for them, factual assertions that could be challenged, and any procedural or structural issues. Do not be diplomatic. Identify the 3 points you would press hardest in your response and explain why each one is vulnerable. Do not add citations of your own. Paste your draft motion in after that prompt. What Claude produces is an adversarial critique, the 3 weakest points identified and explained, with the reasoning opposing counsel would use against each one. The value here is not that Claude finds things you missed. It's that Claude names the vulnerabilities you already sensed but hadn't fully articulated. Most practitioners who run this workflow find at least one thing worth tightening before filing. One note: do not use Claude to find or verify the authorities it mentions as weak. Run every legal citation through Westlaw, LexisNexis, or Fastcase before you act on any research-level output. The stress test is structural and argumentative. Keep it there. Workflow 4. Deposition Architecture. This is different from witness prep, and it's worth being clear about that distinction before we go further. Witness prep covers the witness, what they'll say, where they're vulnerable, how to prepare them for cross. That workflow is already on the channel. Deposition architecture covers you. You have the documents. You need to build a questioning sequence that leads the witness somewhere they don't want to go. That means identifying the inconsistencies across documents, working out the sequence in which to introduce them, and knowing before you walk in what the single most important admission is that you're trying to get. Claude reads the documents and maps the architecture before you sit down. Here's the prompt. You are assisting a litigator preparing to depose the CFO of the defendant company in a securities fraud matter. These are the key documents: emails, board minutes, and financial statements. Identify 1. The 3 most significant inconsistencies or contradictions in the documents that I should press the witness on. 2. The sequence in which I should introduce documents to maximize impact. And 3. The single most important admission I should be trying to get. Explain your reasoning for each. Adapt the role, the document types, and the subject matter to your matter. The structure holds across practice areas. What Claude produces is a strategic map of the deposition, inconsistencies ranked by significance, a recommended document sequencing, and the target admission with the reasoning behind it. Claude isn't doing the cross-examination. It's doing the document analysis that lets you walk in with a plan rather than a pile of exhibits. Workflow 5. The settlement read. The negotiation is done. Everyone wants it over. The settlement agreement gets executed with less scrutiny than the original contract because the parties are tired, because the deal is done, because everyone has moved on emotionally before the ink is dry. 3 years later, a clause nobody read carefully becomes the new dispute. The non-disparagement clause, with no carve-out for legal proceedings. The confidentiality scope that nobody checked covers the existence of the settlement, not just its terms. The release language that covers unknown claims your client didn't know about at the time. Claude runs the future read, identifying every provision that constrains your client's conduct long after the case is closed. Here's the prompt. Read the settlement agreement. Identify every provision that could become a source of dispute or constraint on my client's conduct in the next 3 to 5 years. Focus on confidentiality scope and whether it covers the existence of the agreement, non-disparagement language and any carve-outs for legal proceedings, the scope of the release and whether it covers unknown or related claims, and any ongoing obligations or reporting requirements. Flag ambiguous drafting and explain what the ambiguity could mean in practice. What Claude produces is a future-facing risk assessment. Every provision that could constrain your client, what the ambiguity means in practice, and what you should fix or clarify before execution. Your client signs once. They live with it for years. This read takes Claude about 30 seconds. The dispute it prevents takes considerably longer. 5 workflows. 1 full matter. Matter intake on day 1. Orient to the dispute before your first substantive read. Document triage in the early stage. Map what you have, what's missing, and what to ask the client. Motion stress test before filing. Find your weaknesses before opposing counsel does. Deposition architecture before the deposition. Map the inconsistencies, sequence the exhibits, identify the target admission. And the settlement read before execution. Read the agreement for what constrains your client in 3 years, not just what it resolves today. None of these workflows replace your judgment. Each one makes the judgment you apply sharper because you're applying it to better information faster. 3 things that are yours. First, legal research. Claude does not have access to Westlaw, LexisNexis, or Fastcase. It cannot verify that a case exists, that a citation is accurate, or that a legal proposition is current. Any legal authority Claude mentions, in a stress test, in a triage, in any output from any workflow in this episode, must be verified through your research tool before it goes anywhere near a filing. This is non-negotiable. The Hallucination Files series covers the professional consequences of getting this wrong in detail. Second, jurisdictional judgment. Claude drafts in a generic common law register unless you tell it otherwise. Always specify your jurisdiction explicitly in the prompt. Then apply your own jurisdictional knowledge to everything it produces. Claude doesn't know your specific court, your specific judge, or your specific local rules. Third, the judgment call. Whether to file the motion. Which deposition line to press. Whether the settlement is good enough. Claude can analyze the inputs. It cannot make the call. The professional judgment at the end of every workflow in this episode is yours. That's not a limitation of Claude. It's the correct division of labor. 5 workflows: matter intake, document triage, motion stress test, deposition architecture, and the settlement read. Each one takes minutes. Each one changes what you're applying your judgment to when it counts. The prompts in this episode are starting points. Adapt the role, the jurisdiction, the matter type, and the specific task to what's in front of you. The structure holds. If you're serious about using Claude on legal research and drafting without professional risk, we're building a complete verification system for exactly that. A practical protocol for everything that involves Claude and a filing. More on that soon. That's the episode. See you in the next one.